Wasn't President Obama right in his inauguration speech to say, "We reject as false the choice between our safety and our ideals"? Yeah. When he raised this with Secretary Clinton, did he ask specifically, as the judge's final sentence says, for the United States government to consider changing its position or itself putting that information into the public domain? On the question of whether British security services have been complicit in torture or not, I hope the investigation of the Intelligence Service Committee and the Attorney General will provide answers. But, Madam Deputy Speaker, in issuing a public interest immunity certificate in this case, the answer of this House must be that the Foreign Secretary has stood in the way of allowing justice to take its course.
Madam Deputy Speaker, these cases are indeed illuminating of the judgment of ministers, but also illuminating of the judgment of those who would aspire to be ministers. And in this case, although there was a very large lack of questions in the rant of the honourable gentleman, I will go through his points. He first of all has a fundamental confusion between that which is necessary for justice, which is that the Defence Counsel have full access to all the documents that are necessary for that justice to be achieved, and the interest, which is a perfectly legitimate one to put, in public debate. Well, he shakes his head, but I'm sorry, the justice is served by the individual in question having his rights to a proper trial, and that is served by him having full access to the 42 documents that are at issue. The 42 documents that are referred to were given to the Defence Counsel for Binyam Mohamed in significant part as a result of the representations of this government. And that is the way in which government is served. So when he talks, as he did in his first few seconds, of a cover-up of torture, he is neglecting the fact, first, that Binyam Mohamed's lawyers were given this documentation, and secondly, that the Attorney General are looking in detail at whether or not there is anything complicit about the United Kingdom's role in this place. Secondly, he said, and I think it's worth the House, when Hansard is published, looking at this, that the Honourable Gentleman said that the threat to our security came not from sources that we debate often in this House, whether terrorism or elsewhere, but there was a threat to our national security from our closest ally, which the Intelligence and Security Committee has said is critical to saving British lives because of the intelligence that they provide. And I think that when he has had a chance to look at his remarks, he will realise that you cannot quote President Obama's inaugural speech on the one hand and deny what his National Security Council says on the other. And I am happy to stick by what President Obama said. The National Security Council, which sits in the White House, speaks for the US government, has said, well, the Honourable Gentleman shouts they haven't asked. They made a public statement last night about this case, and they have been absolutely, resolutely clear about this case. Finally, Madam Deputy Speaker, the position of the government in never condoning, cooperating or authorising torture is absolute, and our fulfilment of our international responsibilities in this respect, moral and legal, is absolute. And that is why we never condone, cooperate or authorise torture, and why any allegations thereto are taken with the utmost seriousness and investigated by the highest legal authorities in the land.
Order. Could I please ask, as many members clearly are hoping to catch my eye, for single questions, not statements, and perhaps a concise reply. Karen Buck.
Deputy Speaker, as my right honourable friend is aware, Binyam Mohamed was resident in my constituency, and I would just like to put on record the fact that I am grateful for the very regular and extensive briefings I have had over the last year from Foreign Office officials. Of course, these allegations are of the gravest kind and warrant legal and parliamentary scrutiny. It is also true that Mr Mohamed is very frail, very sick. We were led to believe that his release was imminent very recently. What urgent steps is he now taking to make sure that my constituent is released from illegal detention and returned to this country as soon as possible?
Madam Deputy Speaker, we are pursuing precisely his return at the highest level, including in discussions with Secretary Clinton and with the appropriate US authorities. I understand the urgency that she has brought to this case, and we share that sense of urgency, and we're We are working as fast and as hard as we can. It's not just she who's paid tribute to this, but the lawyers for Binyam Mohamed have also written to us about the efforts of Foreign Office officials in this respect to ensure his return to the UK.
Edward Garnier.
Thank you. May I assure the Foreign Secretary that I entirely accept the points that he's been making about the need to be sensitive with intelligence sharing for the reasons that he's outlined, and none of us is so naive as to think that it would be sensible to do anything about that. Could I ask him, however, when he and the attorney have finished investigating allegations of British complicity with unlawful rendition and torture, if that is what he is doing, if a case is there to be answered, that case will be answered in public and will not be subjected to some form of secret process?
Secretary of State.
Well, the Right Honourable and Learned gentleman speaks with some authority on these matters. The case that is now before the Attorney General relates to the allegation of complicity in torture. It's not a rendition case. The Attorney General has been brought in on the basis of the recommendation or the representation by the Home Secretary as soon as the court issued its judgment in October. And I'd want to get the precise legal processes clear, but I can assure him that it will be done according to the law of the land and the way in which the process has been set out to defend the rights of the individual and British justice in this case.
Mr. Kim Howells.
Madam Deputy Speaker, given that my right honourable friend has informed us that confidentiality in the handling of information between agencies is a cornerstone of all intelligence relationships, and especially between this country and its most important ally, the United States, and that, as the judges say, release of the information at issue here is not through the United Kingdom but through the United States, will he confirm that allegations about the complicity of our agencies in this case must be referred to the Investigatory Powers Tribunal, which is the only body that has the legal power to investigate fully any individual allegation of misconduct by the UK agencies? And will he accept that the Intelligence and Security Committee's own continuing investigations into the policy of our agencies in respect of the US rendition programme may be helped by us being given the 42 documents mentioned by the judges, which my committee has not yet seen, contrary to what the judgment says?
Absolutely, Madam Deputy Speaker. I mean, I think I'm right in saying that anyone can make representations to the tribunal, and that remains the case. But obviously the Home Secretary has referred it to the Attorney General, and it's certainly the case that the Foreign Office has attempted at every stage in the development of this case since last summer, when these documents came to light, to keep the ISC informed in a full and open way, and that's certainly our determination for the future.
Mr. David Davis.
Mr. Speaker, I have to tell the Foreign Secretary that what he's been saying today seems almost entirely inconsistent with what's been said by the judges yesterday. He said that the information that they want to reveal is highly classified secret intelligence. They say in terms in paragraph 68 could not possibly be considered as highly sensitive classified US intelligence. He says in absolute terms it's covered by secrecy requirements of intelligence sharing, which we all understand the basis of that. They reiterate the argument of the special advocates, which says there can be no confidentiality in evidence tending to show the commission of a crime, that the redacted paragraph should be made public, and to do otherwise would be to conceal the gist of the evidence of serious wrongdoing by the United States, which have been facilitated in part by the United Kingdom government. That's the substance of what this argument is about today. But the question he must answer is, did he or did he not give the judges the reason to say no fewer than 8 times, not once, 8 times, that there was either a threat or a grave threat of intelligence being withheld, either in his public or his secret representations? He's reiterated again today from paragraph 11 of his own public immunity application, when he quotes a letter from John Bellinger, which says in terms that the public disclosure of this information could, and I quote, harm existing intelligence information sharing arrangements between our 2 governments. Is that or is that not a threat, and will he please seek to get it lifted?